All right, happy Friday night, everybody. Donald Trump is going to be a convicted felon by Election Day 2024. I do not think that that felony conviction or convictions is going to come from the Mar-A-Lago documents case, and I will explain why shortly. Along those lines, Donald Trump already has 34 indictments out of Manhattan. Several of those counts are for felonies. I believe that trial will be concluded before Election Day. I believe Donald Trump will have felony convictions against him resulting from that trial, at least some. That is not a case that is going to result in any threat of prison time or jail time for Donald Trump. There are three other indictments that are stacked up, two of which are going to come within the next month. The first of those being Fani Willis's what I'm expecting to be a fairly expansive conspiracy set of indictments out of Fulton County, Georgia, relative to Trump and his little buddies' efforts to overturn the election results for the state of Georgia following the 2020 election. And that's all pretty well documented at this point. The January 6th committee did a lot of work on that. It involves fake electors, all of that stuff. And I covered that in the video that I put up last night about felony charges that are coming for Trump. So actually there are four sets of indictments coming. So there's Georgia, there's Jack Smith out of Washington, D.C., which I think is coming some point in the next 2 weeks relative to January 6th, the insurrection, and Trump and his friends' efforts to overturn the 2020 election at the federal level. That is also going to be an expansive conspiracy case that's going to encompass anywhere from 10 to 15 people. And the two other areas that Jack Smith is investigating, one is Trump's fundraising, which took place following Election Day. That's going to be a massive conspiracy situation involving wire fraud, all kinds of deception charges. And then the last one, remember in the first indictment that we got from Jack Smith, there were two instances listed in there in the fact pattern section of that indictment where Donald Trump was showing classified information and classified documents to people who did not have classified or the required security clearances. And that's dissemination of top secret information, which is much more serious than just simply possessing it. And Trump has disseminated it. And I guarantee you that Jack Smith has multiple other examples of Trump doing the same thing. But those took place in New Jersey at Trump's Bedminster golf course. So there's going to be an indictment for that as well. So 4 sets of indictments yet to come. But let's get back to Southern District in Florida. So Jack Smith, about a week ago, he and his team filed a motion with the court saying, we want a December trial date in this case. Earlier this week, Trump's attorneys filed on the 10th, which I think was Monday, they filed a response to that opposition saying, we don't want there to be a trial date in this case. And we'll get to those reasons why. And then on the 13th, yesterday, Jack Smith and his team filed a response or a reply to Trump's attorney's opposition and just absolutely shredded them. Now, Judge Eileen Cannon, who we're familiar with from the special master situation from last fall, who was so hard in the tank for Donald Trump that she got rebuked in a humiliating fashion from the 11th Circuit Court of Appeals, a panel of 3 judges, 2 of whom I believed were appointed by Trump as well as her. And I mean, they just spanked her and basically, you know, in no uncertain terms, stopped just short of calling her an idiot and that she didn't know what she was doing. And I'm holding out a little hope right now that she has been sufficiently chastened by that and that she's not going to pull anything in this case. But we'll know for sure by next Tuesday. Because, you know, on this issue of the trial date, since the judge has prosecution's motion, defense's oppo, and prosecution's reply, she can rule on this at any time. There is a hearing set for this coming Tuesday, July 18th in the afternoon. And at a minimum, she's going to have to make a ruling by then on this issue of the trial date. So, Jack Smith and his folks filed their initial motion, asked for a trial date of December, I think it was December 11th of this year. Then we got their opposition from Trump's attorneys. And one thing that I should say, and I'll talk about this more in a second, the difference between this case, the Mar-A-Lago documents case, and all of those other indictments that I mentioned, none of those other indictments or sets of circumstances involved classified documents or documents with any classified markings. That is a fact that is unique to the Mar-A-Lago documents case. And that, I think, under certain statutory structures is going to be the reason why this trial may eventually get kicked beyond Election Day, but not necessarily so. But we'll talk about that more in a minute. Now, to give you guys some background, when writing motions and writing oppositions and replies to oppositions as attorneys, it's one of my favorite things to do because you can be extremely creative. You can write just about whatever you want as long as it's more or less true and in good faith. You can make arguments all day long. You can come up with creative analogies or creative positions, creative arguments. You can't really get creative with the facts, though. Your facts have to be your facts. You can spin them in certain ways, but you need to not go too far in that process because as attorneys, it's like, you know, you've got to protect the credibility of your client when he's in front of a jury. You got to protect your credibility as an attorney when you're presenting things to the court that are going to be read by the judge, because you're probably going to be in front of that judge again. And, you know, plus it's just the right thing to do, you know, not lie to the judge. So the judge is going to rule on this probably next Tuesday afternoon. But as far as the opposition from Trump's attorneys, I mean, they just go completely off the rails right out of the gate. And what do I mean by that? In their second paragraph opens up with the following. This extraordinary case presents a serious challenge to both the fact and perception of our American democracy. Wow, that sounds serious. The court now presides over a prosecution advanced by the administration of a sitting president against his chief political rival, himself a leading candidate for the presidency of the United States. So they're painting this the way Trump is painting this, but they're not going overboard with it, okay? Trump consistently has been painting this as Joe Biden is prosecuting me because I'm leading him in the polls. And that's the only reason I've done nothing wrong. His attorneys kind of get up to the line a little bit with that, but they don't go that far with it. But they do say, you know, because of this unique circumstance, you know, the court needs to take a measured approach. Thus, pursuant to this one code section, based on the extraordinary action or the extraordinary nature of this action, there is most assuredly no reason for any expedited trial in the ends of justice, blah, 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 blah. So that's their first little bout of, you know, creatively trying to frame this case the way they want it to be framed, which has nothing to do with reality. Because not only does Joe Biden have nothing to do with this prosecution, Merrick Garland doesn't even have anything to do with this prosecution. Jack Smith is an independent prosecutor, and he's doing his own thing. Now, second part of their creativity, which again, if they'd have had any sense as attorneys, they would have left this out. The intersection between the Presidential Records Act and the various criminal statutes at issue has never been addressed by any court, and in the defendant's view, will result in a dismissal of the indictment. There's zero chance of that happening, and the Presidential Records Act has absolutely nothing to do with this case. But they put forth as reasons herein, as reasons for their saying, we shouldn't have a trial date at all in this case, and if you're thinking about it, it should be beyond Election Day. is because we expect there to be dispositive motions filed in this case on novel legal issues which have never been before any court before, which are going to result in a dismissal of everything. It's silly. Taking that position is silly. And they know that taking that position is silly. And they know that taking that position with this judge, even though she may or may not be fully on Trump's side, is silly. And it makes them look silly to the judge. I mean, I'm sure that she read that and she's like, yeah, right. Good luck with that. So they go through a whole bunch of silly reasons for why there shouldn't be any trial date in this case. It should just be kicked out in perpetuity beyond the election. And in doing so, they talk about the amount of discovery that the government has already produced and the amount of discovery that the government produced promptly, almost immediately after filing the indictment. The initial document production was substantial and voluminous. Therein, the government produced more than 428,300 records in excess of 833,000 pages, consisting of approximately 123,000 emails, 305,000 documents gathered from over 90 separate document custodians. The initial production also included some 57 terabytes of compressed raw closed-circuit camera TV footage, approximately 9 months worth of footage from the security cameras in and around Mar-A-Lago that showed Walt Nauta moving all the boxes. Now, I'll try not to skip around too much, but I am going to refer to one thing in Jack Smith's response to that paragraph in Trump's attorney's document. He's basically saying they're completely misrepresenting what the situation with discovery is. For example, the government's document production included a set of key documents referenced in the indictment and otherwise determined by the government to be pertinent to the case. They sorted them out. Jack Smith's team completely organized everything that they produced to Trump's attorneys and said, these are the key documents as they relate to the indictment itself. In addition, for the defendant's convenience, that's how you build credibility with a judge, the government included with its first production a discovery log, basically a table of contents. Although the government's production included over 800,000 pages, the set of key documents that I said earlier was only 4,500 pages long. And they're saying we can't get through that in 6 months. The government similarly identified to the defendants a small subset of key CCTV footage referenced in the indictment or otherwise pertinent to the case. And although the CCTV footage the government obtained and produced comes from various months, the defendant's characterization of the footage as being 9 months worth of footage is misleading. And so Jack Smith responded to that by saying, we meticulously organized all of this stuff. We tabbed it, we put it in order, we segregated what's important, we told them what's not important. There are some things we just have to produce because they are in our possession. We told them those things don't matter. We told them exactly what we're relying on in bringing the indictment and in bringing the case. And Trump's attorneys have misrepresented those circumstances to the court. Now, let's talk about CIPA. That's an acronym, CIPA, Classified Information Protection Act. That deals with, it's a statutory structure for basically including a bunch of other things. You know, it's like, how is a court supposed to handle a situation where you got a criminal trial involving classified documents? And in a lot of that structure are the things which could cause this case to get delayed, the trial in this case to get delayed. But that would only be in the court's attempts to adhere to the requirements of CIPA. Or it should be anyway. And, you know, so then we get to, you know, so we got this reason for continuance, that reason for continuance, we shouldn't have a trial, that reason, CIPA, continue. Just delay. Then they bring up a couple other things, which I think are interesting and equally silly. Um, One they already brought up. As noted above, this court will need to evaluate the intersection between the Presidential Records Act and the various criminal statutes forming the basis of this indictment. No, the court won't. The Presidential Records Act literally has nothing to do with this case or with documents that bear classification markings of any kind, specifically excluded from the Presidential Records Act. The Presidential Records Act has to do with personal records, records that are created by the president or received on a personal basis, a gift from somebody, a letter from somebody that does not contain classified information. It gives you a tremendous amount of insight into Trump's attorney's view of the facts in this case and the indictment in this case and the charges that were actually brought. If they're relying on the Presidential Records Act, it's basically an admission that we don't have a defense to this case at all. So we're going to bring up, shiny bauble, Presidential Records Act and try to distract everybody with that. Secondly, moreover, also as noted above, the defendants anticipate pursuing constitutional and statutory challenges relative to the authority of the special counsel to maintain this action. And they're going to challenge the classification status of some of these documents. There is absolutely no basis, statutory, constitutionally, or otherwise, to challenge the existence of the special counsel, the power of the attorney general to appoint a special counsel, or the power of the special counsel who has been appointed in this case to prosecute this case and to bring this case. There's absolutely no basis for that whatsoever. But between those two things, the Presidential Records Act and challenges to the special prosecutor, Trump's attorneys are saying these challenges are going to take months and months and months. And they're all first impression. No court has ever decided these things before. Well, that's garbage. I mean, there was a special prosecutor in the Nixon case in 1974, and the Supreme Court upheld that. So then they get to my favorite. I'm just going to read this paragraph in its entirety. President Trump is also running for president of the United States and is currently the likely Republican Party nominee. This undertaking requires a tremendous amount of time, energy, and effort and will continue until the election on November 5th, 2024. His co-defendant, Mr. Nauda's job requires him to accompany President Trump during most campaign trips around the country so that he can get him things like Diet Cokes and carry his suitcase. This schedule makes trial preparation with both defendants challenging. Blah, 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 blah. So basically they're saying our clients are too busy. They're too busy, they got too much going on. Which is not at all a basis for continuance. They talk more about the campaign, yada, yada, yada. Then comes, okay, that one should have been my second favorite one. This one's my actual favorite reason that they give for the continuance. Paragraph 18. Wow, too many trials. Finally, previously scheduled trials in other matters for both President Trump and defense counsel make it nearly impossible to prepare for this trial by December 23. For example, President Trump and his attorney, Mr. Blanche, are preparing for a March 2024 criminal trial in New York Supreme Court. His attorney, Chris Kise, who is the former Solicitor General for the state of California and the guy who weaseled Trump out of a $3 million retainer before agreeing to do any work, because Chris Kise is credible, not like most of Trump's other attorneys. Mr. Kise and President Trump are preparing for a lengthy civil attorney in New York Supreme Court commencing October 2nd, 2023. New York State Attorney General suing Trump and the Trump Organization for $250 million for various, felony business practices. And his attorney, Mr. Woodward, has 3 trials scheduled in the coming months. United States versus Peter Navarro, who's going to get indicted relative to January 6th. This indictment has to do with contempt of Congress for refusing to obey a subpoena. Then 2 other cases, United States v. Schulman and United States v. Samsel. Those two guys are insurrectionists. They're January 6th insurrectionists who went into the Capitol and beat the shit out of police officers. So there's that. So these 5 or 6 other trials just make our schedules all crazy. Because our clients were so busy doing so much criming, they were criming all over the place and telling others to go do criming and helping others do criming, that there was just criming going all over the place. And now we have all of those trials as a direct result of our clients criming. So that's the end of their motion. Okay, let's get into Jack Smith's response. A couple of things about Jack Smith's response. His team, first, it's like 10 pages long. It's super easy to read. It's written very well, just like the indictment was. There's no BS. There's no hyperbole. They don't need hyperbole because they've got the facts and the law on their side. So they don't have to, bring up shiny baubles like Trump's attorneys do in their document. So defendants Trump and Nada claim unequivocally that they cannot receive a fair trial prior to the conclusion of the next presidential election and urge the court to withdraw the current scheduling order and request the court not even consider a new trial date until some unspecified later time after the trial date. There is no basis in law or fact for proceeding in such an indeterminate and open-ended fashion, and defendants provide none. Boom. That's the whole thing in a nutshell. That's their first paragraph. They're asking the court to do X, Y, and Z. There's no basis in the fact in the facts or the law for the court to grant that request, and defendants have not provided the court with any basis in facts or law for the court to grant that request. Now, let's talk about this for a second before we get too much further. This issue, this hearing that's coming up on Tuesday, is going to be the first actual test of the judge in this case, Eileen Cannon, who, messed around and found out from the appellate court the last time that she was involved with Trump last fall on that special master case. I said, I told you she got spanked pretty hard by the appellate court by issuing orders that were just egregiously in favor of Trump. Like really, really unreasonably so. And the appellate court was like, no, you don't get to do that. So again, I'm cautiously optimistic that she has been sufficiently chastened in that regard and that she's not going to do anything like that again. But setting the trial date next Tuesday afternoon, today's Friday, is the first time that we're going to have an indication of whether or not she's going to be fair and impartial or whether she's going to behave like she did last fall. And she knows it. She knows that this is the first test. She knows that everybody's eyes are going to be on her on this issue. And I hope she realizes that she can't step out of line like she did before, but we will find out. Then they get right to the statute. Any discussion, because there's a statute on the issue of setting a trial date. Any discussion of setting a trial date must begin with the Speedy Trial Act of 1974. It lays out a structure basically that says you got to, once there's an indictment, you got to set a trial date, and that trial date's got to take place within 70 days. And any continuance of that trial date beyond 70 days has to meet a balancing test. It has to be in the interest of justice. It has to preserve the rights of the defendant, and it also has to comport with the public's need, if it's a newsworthy case, for public proceedings. Then they cite a couple of cases. Well, no. Let me backtrack a bit. Election day is like 16 months away. And they're like, defendants have provided no facts or information to meet this balancing test that's within the Speedy Trial Act of 1974 that would satisfy this balancing test in any way, shape, or form. They're just making blanket assertions that, well, there's no way we can get an impartial trial, an impartial jury until after the election day. They don't provide any information in support of that assertion. They just make the assertion. And you don't really get to do that in court. You got to provide evidence or a basis or a reasoning. So defendants' bases for this trial date in 16 or 17 months boils down to 6 points. Alleged significant legal issues of first impression. That's challenging the existence of the special counsel and issues related to the Presidential Records Act. Red herring, those aren't issues at all. The volume of discovery, we talked about that. The government's already addressed that issue. The pendant CIPA process, they may have a point on that one, but that would justify continuing the trial maybe out to like February, and then checking in November or December and seeing where things are and if it needs to be continued out further again. It goes like in a bit by bit kind of thing. 4, the possibility that their dispositive motions might succeed. Again, silly, red herring. There is no motion that they can file in this case that is going to result in a complete dismissal of the indictment and all of the charges in this case. That motion does not exist, even for this judge. 5, the alleged inability to select an impartial jury for trial. Well, again, we just talked about that. They just make an assertion that there's no way we can get an impartial jury until after Election Day, but they provide no evidence in support of that. And last, number 6, their own schedules and those of the lawyers, which there's case law that says I'm too busy is not a basis for a continuance of a trial date. And then they go through and they break these down a little bit more in order. But again, I want to reiterate, the Presidential Records Act has nothing to do with this case. And I made the analogy in a TikTok a couple of months ago, or a month ago maybe. Essentially, when you're charged under the Espionage Act and you're going, oh, no, the Presidential Records Act applies. I'm innocent because the Presidential Records Act applies. That is tantamount to, walking down the sidewalk in a busy city and walking up behind somebody and shooting them in the head, and the police charge you with murder, and you say, I was hunting. That's not murder because I was hunting. So the hunting statute applies and I have a hunting license. That's the level of intelligence here in saying, no, it's the Presidential Records Act. It's an astonishingly bad and dumb argument, which is why Trump's been making it since last August. It has absolutely no bearing in this case whatsoever. Then we go through the discovery stuff, and I talked about that in their response, and the CCTV footage. And there were a couple other minor issues that I don't think matter at all. Then the government lays out, here's what we have left to produce, and almost all of it is contingent upon defense counsel fulfilling their requirements to get their security clearances. And Trump's got, 6 or 8 attorneys that are defending him on this case. Only 2 of them have turned in their paperwork so far to get their security clearances. The rest of them just haven't bothered yet. And now they're saying, well, we don't have time to study all of these documents. And the government's like, you're the reason for that because you won't turn in your paperwork to get your security clearance. Then the government goes on to say, we've already set up a SCIF in the courthouse in Miami, a sensitive compartmented information facility. So they've set up a secure room in the federal courthouse in Miami for Trump's attorneys to be able to go in and look at these classified documents. And they're like, we've put some of the documents in there so far, but we can't put the rest of them in there until they get their security clearances. And they're not bothering to do it. So you can't let them cause the delay and then use the delay that they caused to get a continuance. And then they talk a little bit about CIPA, which again, they're kind of like, yeah, this case may be delayed by the CIPA statute, but it's going to be bit by bit, incremental, not all at once. Yeah, I mean, they do an extremely good job, the prosecution, in their brief of, like, completely, and I do mean completely, dismantling every single argument that Trump and his attorneys make in their brief, except for as it relates to CIPA. And even as it relates to CIPA, they're like, Again, that's a bit by bit incremental continuance issue, not 16 months out of the gate. Okay, so what are my impressions after reading this document? So, reading these documents and having read the indictment, the overwhelming fact that I think is clear is that as of the date that the court filed their indictment and served it on Donald Trump, as of that date, at the beginning of June, they were ready to go to trial that date. The government is ready to go to trial, period. They are prepared, they are organized, as has been demonstrated. They've already disclosed their witnesses, the witness statements. They've got their witness list all set. They know who their witnesses are. They've got their documents. They've got their video. They are prepared to go to trial right now. And granted, defense needs time to do that. You don't get the same amount of time to do that in federal court that you do in state court, county court. Federal court just doesn't work that way because they've got the Speedy Trial Act. Now, CIPA complicates that a little bit, but we've already talked about that, and we'll just see how that plays out. But this is going to be the first test of Judge Cannon. You know, is she going to come in on Tuesday and grant prosecutors' request and say 6 months is plenty of time? You guys, you'll be ready for trial by then, to the defense. Is she going to grant a trial date 2, 3, 4 months beyond December, or which would be still fine, I think? Or is she going to grant the request that Trump and his attorneys make and say, we're not setting a trial date right now? If she says we're not setting a trial date right now, I would view that as an egregious departure from federal procedure in criminal cases. Because one of the reasons why judges are required to set trial dates early on is because all of the other deadlines in the case are calculated based on that trial date. Meaning you get your trial date and you work backwards. Here's where discovery has to be completed. Here's when any witness interviews or depositions have to be completed. This is when you have to file your dispositive motions in the case. This is when those motions have to be heard. Here's the deadline for filing your pretrial motions and their oppositions, and then there's the trial date. So you have to have the trial date in order to set the calendar for the rest of the time that the case is going to be pending. That's one of the main reasons for it. But you have to balance that against the interests of the defendant getting a fair trial and the rights of the public to be kept apprised of what's going on in the case and the public interest in the case. So I will obviously we will all keep our eyes open over the next, what is it, Saturday, Sunday, Monday, Tuesday, 96 hours, give or take, until this hearing Tuesday afternoon, to see if Judge Cannon just issues a ruling on these motions and oppositions before the hearing on Tuesday. And if she does not, then I will expect that she will issue a ruling on the trial date at the hearing on Tuesday afternoon, and then everybody will know where we stand. So I'll see you guys on Tuesday.